As you can see there, attorneys, friends of the court, making their way to the Supreme Court there. They're already seated as they await the arrival of the Supreme Court judges, who are expected to be sitting any time now, as they enter yet another phase where they will be hearing a case challenging President Uhuru Kenyatta's re-election. Those are currently some of the lawyers that have made their way to the Supreme Court. We will be singling them out as we spot those that we know, and that is the Supreme Court currently. A lot of lawyers making their way there, persons that are interested in these hearings, making their way to the court as we await the arrival of the Supreme Court judges. This, of course, being the second time that they will be hearing a case challenging the election of President Uhuru Kenyatta. And of course, these current situation similar, rather different from that of the outcome of the August 8th election, where there was one petitioner. This time round we have three, and that is businessman Haron Mao and two activists who have petitioned Uhuru Kenyatta's win in the October 26th repeat presidential election. And therefore, the pictures that we're getting there are from the Supreme Court. We will be going live there to listen to proceedings. Sam Kitoko will also be giving us an update, and he will be following those proceedings very keenly as we get into yet another phase as a nation, where the Supreme Court will be determining whether or not the win of Uhuru Kenyatta in the recently concluded repeat presidential election was valid. We're getting back into our studio discussion. And to you, Alutalala, your thoughts on secession and your response to Steve Ogola's thoughts there. Do you think the opposition will succeed in dividing the nation? They are calling for some counties to approve the motion on People's Assembly. What are your thoughts on this?
Thanks, Lina. I don't know whether Steve had already concluded his thoughts process, because I think we interrupted before.
I think he had.
But if he had,
yeah.
I just concur with him when he says that secession is not straightforward, it's not easy. First of all, in terms of our domestic dynamics of politics, it is a badly bruising event, because what it is saying is that you, Lillian, if you don't belong to the NASA-friendly zones, then you, and Steve, for example, if he belongs to NASA-friendly zones, then you have to part ways in terms of administration, in terms of geography, and many other things. So locally, it is a very bruising and brutalizing process. In terms of going through the county assemblies, we have seen that they have done in Siaya and a couple of others. Whether they'll succeed or not, really, it can only remain a question of conjuncture. I've been sharing with some of my colleagues, and one factor that comes out is that they think, and I'm tempted to follow their persuasion, that the only consolation here is whether that route that NASA has taken can be sustainable in the long run. Because believe you me, in terms of resources, in terms of keeping the morale of your supporters in one place, it's not easy. On the other hand, of course, you have a menacing government breathing down your throat, because you have actually declared you want to bring that government down, and they are the incumbent in power. They'll use their resources. Even the threat of approaching some of your own loyalists with gifts and favors, as we have known in this country, is very high. So there is this school of thought that, yes, that is the line that Honorable Royal and his team are chasing, but chances are that it may not be sustainable in the long run. We've not been told much about, for example, the other avenue of the boycott, how far it is reached, whether it's working or not. We've not been told. So the whole challenge will remain the issue of sustainability of that onslaught. So I hope that answers your question, whether they will succeed in seceding or not. The answer is it can only remain speculative at this stage. And
of interest is the fact that this bill seeks to separate 40 counties from the rest, and the ones that have been included, I mean, the counties included, the 7 that are not included in that list are Nyeri, Kirinyaga, Tharaka Nithi, Murang'a, Embu, Nyandarua, and Kiambu counties. What do you read into that?
That is also exclusionary on the part of NASA. I think it sort of betrays NASA's own genuine concern, because you are saying, you are trying to tell, the secret message you are trying to communicate is that let us exclude those people. Now that is the kind of approach that will kill the ambition or desire to secede, because then it will be looked at, you are setting up a greater part of the country against another part. So we are moving away from you. You know, we are leaving you alone there. I think that kind of approach, for me, looking at the promoter of this bill, Honorable Peter Kaluma. Peter Kaluma is well versed in matters of law. He's in terms of, he's a law of no mean repute. So he knows what he's doing, he knows what the law says. But then I think in terms of politics, he's just probably just creating that narrative that, listen, if you continue excluding people, we can also attempt to exclude you.
But in his argument, he says that he submitted it after President Uhuru staffed devolution of the growth it needs and retained most of the funds in Nairobi County.
No. As someone who also has a detailed understanding of governance, because I studied governance at the master's level and also observed it over the last 5 years, it's not fair. In fact, I'm one of the believers, will be surprised, who think that the county governments have been given more than they can manage, because they say funds follow functions. What are the critical functions in the national government and in the county governments? If you look at areas that absorb a lot of funds, it's education, healthcare, infrastructure, and security. All these functions are in the national government. But you see, if the estimates are correct, that the national government has been disbursing up to 40% to the counties without having substantive functions. That's why no wonder you saw the Council of Governors trying to create a justification for even reclassification of roads so that they take a greater role in infrastructural development. Education is largely a national function, except for how do you call it? Pre-primary education, which is the function of counties. Security is a national function. Security hasn't been devolved. Healthcare largely is a national function. It's a shared function, but much of it is still a national function. So you can see, I've always wondered how the government is able to disburse up to 40%, considering that the functions at the national level are still a lot and require, it's capital intensive. And look at the staff, the salaries paid at the national level, there's still quite a number. The employees, the people in the civil service are higher in the national government than they are in the counties. So for me, I don't think Kaluma is right in saying the counties have been starved of resources. What they needed to show is how they have spent those resources in the first place, because you have seen that what devolution has succeeded in doing, devolution has succeeded in devolving corruption and devolving elite capture and opportunities for personal aggrandizement. That is the fact as it is. The proper conceptualization of devolution was to bring decision-making to the very lowest level. How many counties really, and I said it before, genuinely engage the people in decision-making processes? My mother in the village, somewhere in Ugenya, in Sega, she ought to know that in this financial year, this village, at least there's 500,000 dedicated to my village, to her village, that will be used to buy a Panadol or other things, or other, let's say, drugs for her local dispensary. That information is not there. In fact, if you write to the county government, most of the county government, they look at you and say, who are you? If you're not an important person, they won't respond. They ignore you. If they call town hall meetings, you go and give your views, they come with a predetermined position and they just want you, they want your signature to just ratify that decision. So I think there's a lot of learning to go on, and I don't think we would use devolution as a key anchor for secession. That discussion will not, as a political statement, it may work in terms of mobilization, but as a legal strategy, that is a dead-on-arrival kind of approach.
Your thoughts, Salutalala? The 7 counties excluded are those from Mount Kenya, and yet NASA is talking about inclusivity.
That is exactly what I said, Lillian, that we don't have a shortage of laws. Laws are there. What we have is a shortage of good people in this country. And I also said that it's not all about law, it's also about politics. So my brother here is right when he says that there is a bit of legality doesn't take far, but I dare say this political. Because one would expect that just like they have taken the motions to 19 county assemblies where they are sure that they command control, one would expect also that the plea for secession would be prominent in areas that are predominantly friendly to NASA. The decision to isolate Central Province, the larger Central Province, or if you like Mount Kenya region, is political. And it's a statement that is based on what NASA has always said is a statement of historical injustices. So it's a political statement that is meant to paint the struggle as being against the rest of the country that is marginalized, against the few who have had the advantage historically to have more, to have better, and to have privilege. So it is a political statement. Whether that statement will bear fruit, again, is a question of speculation. But for sure, that's a political statement. One would have expected that was engaged, for example, that's Jubilee at the moment. So one would have expected that the county that will be left out will be those that are friendly to Jubilee, and those that will be included are those that are friendly to NASA. But the inclusion of Rift Valley in that is a political statement. Yes.
There's the argument.
The question of inclusion, I think, has been wrongly framed. The idea of inclusion being promoted by the political elite is different from the inclusion in the constitution. And we've seen dishonesty in these political elites. If you look at the design of the constitution rests on 4 critical pillars. One, of course, is this robust framework. And two is that the aspect of public vigilance, like now what we're seeing in the courts, the public saying that we must hold people to account. And 3 is that robust, independent, and functional judiciary. And then 4 is, of course, the expanded human rights framework. Then 5, the inclusion. The inclusion bit is this. The Constitution requires inclusion of marginalized groups, women and youth, and persons with disabilities at all levels of government, and that the president, when he's reconstituting the cabinet, he should ensure that the cabinet bears the face of the country, and that appointments are not dominated by, let's say, 2 communities that have formed government. Everybody. That is the kind of inclusion the Constitution requires. But listen, personally, I am litigating in court a matter which requires the 2/3 gender principle. Parliament has failed many times to pass that law. There was a judgment last year, on 29th of March this year, the Mativo judgment, that ordered Parliament to pass that law. They never did pass that law. And then they're talking about inclusion. Where are the women in the National Assembly, for instance? Have they done an audit? There's a law firm that I know that did an audit of the law on composition of at the county assemblies, women, in CECs, the county executive committees, and women in nominated seats, sort of in the assemblies, and there are glaring gaps, including in NASA zones. So when you talk about inclusion, is it inclusion or co-option? That's the question. Because for me, it appears like the political elite are more obsessed with co-option, and you see co-option could be co-option into the club of resource managers, so that if your person is not in government, your person is not at the helm, let's say at the presidency, then you feel excluded. But the manner to feel included is if one of your person is co-opted there. But Lillian, some of this discussion on inclusion or co-option, what I think is co-option in my view, must be understood in the context of our lived reality. There's a reason why Kenya is ranked number 145 out of 183 in the Corruption Perception Index. It's a sad thing. It means that corruption has deepened and widened in this country. And in terms of political contestation such as this, it could be that the struggle for the presidency is not really a struggle for inclusion. It could be a struggle for co-option into that club of privileged resource managers. But nobody ever says that I want to be there so that I can achieve personal aggrandizement. They must use you as a launching pad, you and I, and say, since Kenyan politics is organized along ethnic lines, let us ride on our ethnic blocks to say that we want to be included in that government. But when they're there, all they do, the leaders do, is to reward themselves and tenders and all that. That is why IBC, even in this election, and I've argued there's a critical point in this election: 2013 election, 2017 election, general election, and then the fresh election. Something that has gone completely unattended for. Article 88, Article 88(1), paragraph E, on the role of the IBC, says IBC must regulate the use of money in election. That provision is there in the Constitution, just like voting by secret ballot, you can't exclude it. You can't have an election, Lillian, that matches the framework or the standard under the Constitution. Let me just read that. Part of the functions of the IEBC under Article 88.4, the Commission is responsible, paragraph I, the regulation of the amount of money that may be spent by or on behalf of a candidate or party in respect of any election. This is a constitutional requirement. Lillian, pray do tell me how we are not complying with this provision just because politicians think the money should not be regulated and IBC is incompetent and does not want to craft ways of regulating the money just because Election Campaign Finance Act was suspended, which itself was highly regular. How we are conducting election in which election campaign finance is not regulated, for me, is a misnomer. The same requirement under Article 81 on the principles of the electoral process. Just as it says, Lillian, free and fair elections which are by secret ballot. You can't have free and fair elections which are not by secret ballot. It doesn't meet the threshold. Paragraph number 2 there, just the second issue after secret ballot is an election that is free from violence, intimidation, improper influence or corruption. In the context of election, improper influence or corruption means use of unregulated money. So the Constitution imposes a double standard on a twin requirement on IBC to regulate the use of money. In our context, money is the pathway to corruption because if you allow people illegal sources of money or black money to influence, to support shadow companies, to support candidates, once they get elected, of course, there is that quid pro quo corruption. People must get rewarded for what they invested. So how do you want to fight corruption, even as NASA or Jubilee, when campaign finance was not regulated? The people who supported you, we don't know. That is why the issue, Jimmy Wanjigi can tell us on national television that Uhuru Kenyatta's government was formed in his house. That's an insult to the Kenyan people. We are queuing on the ballot to vote in a president who was already formed, predetermined in someone's house. And is saying that and going and condemned by NASA leaders, including Raila himself, who stands by itself and is applauded. This tells you that sometimes this struggle for inclusion, Lillian, is actually, could as well be a struggle for co-option into the club of resource managers.
As you hold that thought, I'll be coming to you, Prof. Lutalala, very shortly. But as we continue with discussions around the outcome of the Supreme Court decision and the implications of that, let's cross over to Francis Kashuri and Sam Gituku, who are live at the Supreme Court. Good morning, gentlemen. It's a rainy day for you there, rainy start for you at the Supreme Court. But bring us up to speed on who has made their way there when we're expecting the Supreme Court judges to be seated.
Well, yes. Good morning, lady. Good morning, Lillian. It's getting wet here, but we've seen several council making their way into the Supreme Court, for instance, from the IABC, led by Waweru Gatonya, who is the lead counsel in this particular case. And then there are other lawyers like Mahat Soman, which are the other persons that you can remember?
I've seen Amin Nasir Abdullahi
representing Uhuru Kenyatta.
Yes, from the Ogeto and Otachi company advocates. So basically the lawyers are making their way here, but it's about 11:20 or 11:15 or thereabout.
Yes,
the session was supposed to kick off at 11, but I think it's not yet 11 a.m. Supreme Court time.
Come on, we should be expecting the judges to make their way into the courtroom any minute now, but essentially, Lillian, as you've been talking about, it is the pre-trial conference, the day that the judges get an opportunity to, together with the teams of lawyers, to set out the program on how they should be listening this matter, on what issues they should be considering, the contentious and non-contentious issues, so that as the case proceeds, basically expectation is that they should begin the hearing tomorrow, but before then today is the day that they decide on really how to progress.
Absolutely, and compared to what we saw the last time we were here, you can say there is less excitement compared to what we saw in the previous presidential petition. As at this point, there were a lot of people milling around the Supreme Court precincts, but today the situation is very different. Though the roads are barricaded, the security remains heightened here, but the level of interest and the anxiety, the hype, has gone down a little bit. I don't know whether that will translate to what we'll be seeing at within the courtroom. But when you look at the number of legal minds that are in this process, you can still expect that there will be some serious legal showdown. Actually, as even though today we don't expect a lot of drama in terms of listing the issues of determination, there's a possibility there could be raised a preliminary objection, especially on the petition that has been filed by Kioko Kilukumi on behalf of the Institute for Governance, the ones who are seeking that the NASA leader and other leaders from the National Super Alliance team be cited for contempt of court. There's a likelihood of a preliminary objection being raised by some of the lawyers from the NASA team. And other than that, basically the other issues I suspect will be purely procedural to set the stage for what is going to happen likely tomorrow and maybe Thursday, if the oral submissions will be made tomorrow and Thursday. But by and large, the judges are already acquainted with the content of the petition, because the written submissions have already reached them. They have been engaging with the petition and the responses from the respondents. So basically, the petition proper is already underway. All that we're waiting to hear is how the lawyers will be prosecuting the matters at hand.
But I also think something key or crucial that we have seen here is that if you look at the August presidential election, the team of lawyers that were representing the IEBC are somehow different from what we had that time, because I remember senior counsel Paul Mwita was here, Issa Mansour was here, Paul Nyamodi was here. We don't seem to see them this time round. There has been a reshuffle at the IEBC legal team. The lead lawyer last time was senior counsel Paul Mwite. The lead lawyer now, or the captain of the legal team from the IEBC team, is now Waweru Gatonye. And you remember the last petition, a paragraph from the majority judgment is that the judges felt that the legal team that represented the IEBC then dealt with other issues other than that what was in the petition. And so probably those are some of the issues that the IEBC team has identified, and probably try and correct them. They have seen the need to tinker with their legal team, and let's see what the new team is able to deliver in the courtroom. And Leland, without getting into the merits or demerits of the particular case, we can highlight a few issues on how different this petition is, because if you remember, last time it was one of the presidential candidates against the IEBC and against Uhuru Kenyatta who had been declared president-elect. Yes, this time round Uhuru Kenyatta is still the president-elect, but the petition is not from a political party. It is from John Jomue and Khalifa
and John Harun Mau, the former member of parliament for Kilome. The grounds or the prayers are quite similar to what we saw in the last presidential election, because at the heart of it is the seeking to nullify the presidential election that was conducted last month on the 26th. All other issues are related to the first prayer, that is the annulment of the presidential election that was conducted on the 26th. But I think compared to what happened in the last presidential election, there are more fundamental matters of law that the Supreme Court will be expected to deal with now. For example, what is a fresh presidential election? That is one of the questions that the Supreme Court judges will be expected to answer in this petition. Secondly, what becomes of a presidential election, a repeat presidential election, if one of the presidential candidates withdraws? So that's also a matter that we will expect them to tell us in detail, so that probably in future there will be no need for confusion or the kind of a situation we've seen the country put into recently on whether what actually constitutes a presidential election and what becomes of a presidential election if one of the candidates withdraws. So in terms of matters of law, I think the judges have some serious issues to deal with. There was a little bit more of politics in the previous presidential election petition. Compared to this one, I see less politics now, but more fundamental matters of law.
But still, looking at the response, the replying affidavit of Musala Mudavade to the case by ID, what do you call it? ICG, Institute for Center and Governance. Okay, the institution being represented by Kioko Kilukumi. He is saying that looking at the preparations that IBC was undertaking, they feel that it was interfered with, first of all, by the opponent political party in this case. They are citing the issues to do with the memo that was issued by the chairman of IBC against Ezra Chiloba, the CEO of the institution, as well as the redistributive demands that they were never met by the IEBC in getting to prepare for the election. So it is sort of the respondent or the interested party. The respondent, actually, in this case, the National Super Alliance, is saying that the circumstances that were existing before the fresh presidential election could not allow for the holding of a credible election, and so you're saying that based on those, then the presidential election should be declared a nullity.
Absolutely, and when you look at the responses that have come from the respondents, while the National Super Alliance is not a petitioner this time, or its presidential candidate, because he already withdrew from the race on the 10th of October. One of the responses from President Uhuru Kenyatta is that he claims that Helef Khalifa and John Jomwe and John Harumau, the petitioners, are surrogates of NASA. So that is one of the issues that are likely to come up in the course of the petition, because the petitioners have insisted that they have applied, or they have made this application on their own volition, so that they can protect the rule of law and ensure that an election is conducted in strict compliance with the Constitution and the applicable election laws. So you will most likely will see some some back and forth between the legal teams, especially when the respondent, that is President Uhuru Kenyatta, claims that the petitioners are surrogates of his main rival, or would have been his main rival in the presidential election in October. But by and large, you will still expect some serious political fireworks when the petitioners, when the legal teams representing the petitioners and the respondents engage in the courtroom.
Well, Lillian, we'll be expected to hear all these matters as soon as the hearing begins, probably starting tomorrow for 2 days if it is to be consistent with what we had in August. But it's getting... Is it wetter? We need to leave so that as we wait for the judges to make their way into the Supreme Court and start this process of the pre-trial conference. Lillian, if you can hear me?
Some stay dry. We don't want your suits getting messed up in that rain. That's Sam Kituku and Francis Gashuri. They're following the proceedings that are expected to start very shortly. Of course, this being the pre-trial conference, the Supreme Court judge is expected to be seated any time from now. We've seen a galaxy of lawyers there at the Supreme Court, and this time there are 3 petitions, meaning, as you've seen, there'll be more lawyers who will be arguing out their cases, although we do not expect fireworks as such today, this being the pre-trial conference, and we're expecting the Supreme Court judges to be sitting, to be outlining the modus operandi. I'm going to be talking to our guest analysts in studio here on what we are likely to expect, starting with you, Alutalala. How different this petition is. At the heart of this is an attempt to nullify the repeat presidential election, and we're looking at some key issues here that are likely to be answered by the Supreme Court judges or asked, or these are questions that are likely to arise. What is a fresh presidential election, and what becomes of a presidential election if one of the candidates withdraws? In the just concluded repeat presidential election, we know that one of the candidates withdrew, that is Raila Odinga. So simplify this for us and the jargon that we're likely to be hearing in coming days.
Thanks, Lillian. I think we go back where we began, and in a way we have traversed that before. You see, the crux of the petition, as we have rightly put it, is on whether or not this election complied with the dictates of the ruling of the Supreme Court. That is the crux of it. That's where it hinges. However, to go a bit further sublime, you look at Article 138, 1 and 2, Sabbatical 1 and 2, one which says that where there is only one candidate nominated, then only that one candidate shall be declared the president, and you need not proceed to hold elections. Then Sabbatical 2, which says that where, however, there's more than one, then elections shall be held in 290 of the constituencies. So, as I say, the key question that the justices will be asking themselves is, when we annulled the election under Article 140 of the Constitution, which, as I've said, simply says that there will be fresh elections. Once it's annulled, there will be fresh elections within 160 days. And we directed that fresh elections be thus held. Did IEBC correctly interpret our instructions? According to IEBC, a fresh election as ordered by the Supreme Court did not entail conducting fresh nominations, 1. 2, it did not even entail all candidates. It only entailed the petitioner and the respondent. That was how IEBC interpreted it. And so Harun Mau says, look, that interpretation by IEBC, which IEBC based on a decision in 2013, which most of us have described as obiter dicta, is faulty. So Harun Mau is saying that, look, that is a faulty interpretation of Article 140 under which the election was annulled. And that is a faulty interpretation of the decision and direction of the Supreme Court. According to Harun Mau, the correct interpretation is this literal. My younger brother always refers to textual interpretation, as it is. It's a positivist interpretation of law. Is this, that fresh elections shall be held within 60 days. There are two limbs there, fresh elections and within 60 days. IEBC got it right on the last limb, within 60 days. But Harun Mau says, no, you got it wrong on the first interpretation, which is fresh elections. So really that is what the Supreme Court will be laboring upon for the larger part of it. The rest really become accessories. For instance, if the Supreme Court will say, yes, fresh elections meant conducting fresh nominations, payment of nomination fees, gazettement of the candidates, then that agreement with that interpretation will lead towards the annulment of that election, because that was not done. But if the Supreme Court will be of the view that, look, fresh election did not mean that. In other words, all you needed to do is to bring in the petitioner and the respondent, that is President Uhuru Kenyatta and Prime Minister Raila Odinga, then yes, the election will be held as having been constitutional and President Uhuru Kenyatta's victory will be upheld. For me, that is where the main decision revolves. The rest are accessories.
On the IEBC and whether they should have started by nomination of candidates before gazetting the names, let's talk about that. The IEBC question and how this is likely to affect the outcome of the Supreme Court decision.
Lillian, let me just make a comment related to this case. I think this time, both councils, the petitioners and the respondents, need not to overwork themselves. Because I'm of the view that this hearing is part of just the process of reaching the determination. That is already, the court is walking into this case already with a formed opinion about the Kenyan political context. And it's very easy, since they set the threshold so high in terms of election management, opportunity to point out illegalities and irregularities, once they are there, they should nullify. But when they come to sit and they reflect on the political lived realities, they might as well decide, okay, fine, we'll just listen to those illegalities and irregularities, and seeing IBC's conduct, we may not just even, we may say that this case for nullification, but for nullify. I think if this case is nullified, if the election is nullified, the credit will go back to the Supreme Court, not necessarily the petitioners. If the case is, if Uhuru's victory is upheld, the credit will still go back to the Supreme Court and not necessarily a robust defense by the respondents. Now, in terms of the issues for determination, if you look at the Njonjo petition, which is the sort of the pilot petition, there are there's the preliminary issues, processual issues, substantive issues. The preliminary issue, which the court must determine and dispose of before it can examine the petition on merits, is whether Raila's withdrawal had the consequence of effectively cancelling the election. Once the court makes a determination that the withdrawal of Raila meant elections stood cancelled, there Raila was arguing, then they'll be examining the rest of the issues as a matter of documentation. Because they'll be saying in essence that any other process after that was just null and void and ought not to have taken place. But nonetheless, since it took place, let us examine it for purposes of making recommendations going into the second fresh election. But if the court is of the view that Raila withdrawal was inconsequential, then it will examine the petition on merits. Now, the petitioner has listed 10 issues that deal with illegalities and irregularities, some of which include, of course, the failure to conduct fresh nominations, irregular inclusion of Raila's name on the ballot paper, depriving NAS opportunity to nominate alternative candidate following Raila withdrawal, irregular inclusion of Jirongo on the ballot paper, illegal appointment of constituency returning officers, discrimination of the other 5 candidates in that they had only 2 days to campaign, failure to audit ICT system, illegal transfer polling stations, failure to conduct election in 27 constituencies, and the 10th one is the dubious voter turnout. Those are issues of illegalities and irregularities, and each and every one will be examined based on the evidence tendered and the respondents will have an opportunity to rebut them. Then there are other issues that don't deal with the law per se, with specific provisions of the Constitution, but in terms of management of elections, they're very important. What I'm calling the substantive issues of election management, not of law, but of election management generally. And the judicial petition also lists about 10 issues. And he says the NASA boycott must be examined in full context, because we live in a democracy that says the president of the republic should be elected by the whole people, by every voter. If you have an election, however well managed, where a critical section did not participate, what does it mean? Manipulation of the electoral process, if you could give me, let's say, half a minute to just highlight this. Manipulation of the electoral process, the passage of these laws in the context of what Jubilee was pushing, ostensibly to improve election management, and gazettement of holidays, you know, to minimize opportunity for court to stop the election. Thirdly, the deprivation of candidates' opportunity to campaign, the threats to judges, poll violence, use of excessive force by police, threats and intimidation to IBC commissioners, partisan posturing within the commission, and the subsequent resignation of Akombe, and the statement made by Chebukati that sort of buttressing Akombe's claims, and then ultimately the poor voter turnout. What does it mean in terms of popular mandate? You see, those issues concern elections generally. Basically, what the petition is saying, that election is not a mechanical exercise that we just conduct either way anyhow. If they're pushing the narrative that election, you must speak to the soul of election, the proper intention of election. The election should give us a result that reflects to a greater extent what is truly the popular will of the people. Can you say that you know the popular will of the people in a poisonous, toxic environment? See, now that's a question of how elections are managed generally. So I think the court will examine that, and I think the argument that the respondents may put across is that, well, most of these so-called substantive issues were actually a creation of NASA, and that if you create a hostile environment, because this is a shared responsibility, Jubilee and the police through the law enforcement agencies contributed to part of this hostile climate, then you shouldn't benefit from a process that manipulates the election itself.
Right. Thanks for your thoughts. As you can see, the Supreme Court judges seated, albeit the fact that it is 6 of them that are currently seated. Justice Mohammed Ibrahim doesn't seem to be part of the judges that are seated, and therefore 6 of them are currently seated, of course headed by Chief Justice David Maraga, and we will now of course be getting into the Supreme Court live to hear the proceedings there. This is expected to be the pre-trial conference. We're crossing over now to the Supreme Court for the rest of developments there. Let's listen in.
Use my colleagues as regards the first petition, if I have your permission. The petition number 2.